I'm Professor Findlay Stark. I'm Professor of Criminal Law here in the Faculty of Law. And today I'm going to give you an example of the kind of issue that we deal with in a basic criminal law course. Now, criminal law is a mandatory paper at Cambridge, as I'm sure it is at most law schools in the country. And what a criminal law course tends to focus on is what we call the substantive criminal law. That's the definitions of offences and the modes of holding people liable for those offences. Things like procedure and evidence and criminology tend to be left to the second and third year of the degree in Cambridge, and I'm sure it's similar elsewhere. I will be asking you a lot of questions today. I'm not presupposing any legal knowledge, and there are no silly answers, so please do just respond, even if it's intuitively. Before I can get on to analysing the example that I want us to look at, I've got to teach you the basic building blocks of a criminal offence in England and Wales. As you've probably worked out by now, lawyers are pretentious and they use quite a lot of unnecessary Latin. So I have to teach you some unnecessary Latin. The first bit of unnecessary Latin is actus reus. So by the actus reus, what we mean is what the defendant must have done or brought about in terms of the consequences of their action for it to constitute a crime. We add to that the mens rea, and by that we mean the fault element that the defendant must have had at the time of perpetrating that actus reus. If we've got those two elements, the third thing is a negative element, and that is the absence of any defences to criminal liability. I won't speak much about those today, but they are an important part of any criminal law course. Let's make that less abstract by building a definition of a criminal offence. I'm going to focus on murder today. So who wants to tell me what they think the actus reus of murder is? The thing that you have to actually do or bring about to be a murderer. Yes?
Physically, like killing somebody. So, for example, by stabbing.
Yeah. So anything that causes the death of a human being. Now, more formally, we say the unlawful killing of a human being under the king's peace. Now, if you wanted to go and find the definition of murder and find that written down, where do you think you would look? Just as a matter of common sense, what would you be looking for? Something like, I can hear murmurs of statute. You might think so. You might think there's something called the Murder Act. There is not. We look in a very old book. So this person, Cook, spelt Coke, just to be difficult, law is like that, wrote down at some point during his lifetime, there's debate over when he did it, that the actus reus of murder is the unlawful killing of a human being under the king's peace. And since then, we have adopted that as the definition of murder. He's something that's called an institutional writer. And so he still has authority, even though he was writing centuries ago. So that's where we get the actus reus, the unlawful killing of a human being under the king's peace. What do we think the mens rea of murder is? What has to be going on in the head of someone whilst they're causing death to be a murderer? Right at the back.
Like they must have the intention to kill someone.
Right. So one form of mens rea in murder is the intention to cause death. Now, I'm Scottish. The propensity for violence is there. So imagine that I set about my enemy with a baseball bat and I hit them around the head a few times and I kill them. And I say, well, I didn't mean to kill him. I only wanted to really hurt him. How many of you think I should still be convicted of murder in that kind of scenario? Right, exactly. And that's what our criminal law in England and Wales says. It says that the mens rea of murder is an intention to kill or cause grievous bodily harm. Now, nowadays, words such as grievous bodily harm are not quite as meaningful to jurors, so we tend to translate that to really serious harm. So as long as you intended to really seriously harm the person that you kill, you are going to be convicted of murder. And again, there's no statute that tells you that. To work out the mens rea of murder, you have to go to a judicial decision called Cunningham, where the House of Lords, which used to decide criminal cases before it became the Supreme Court, said that yes, the mens rea is an intention to kill or cause grievous bodily harm to a human being. There then, we have our definition of murder. What I now want to do is apply that to an example. And the example I have chosen is as follows. Andy and Ben decide to rob a bank. The plan is that Ben will go inside and demand money from the bank's employees. Andy will then act as the getaway driver. So that's the basic plan. But they wonder whether they will encounter any resistance whilst carrying that plan out. And they agree that, should it be necessary for Ben to escape, Ben should use his gun to threaten a bank employee. Now, Ben reassures Andy, who is worried about Ben's violent reputation, that Ben will not actually shoot anyone in that scenario. That's the more developed plan. When it comes to executing this plan, after entering the bank and demanding the money, Ben panics when he's approached by Clive. Ben shoots Clive before running out of the bank to Andy's car. Andy drives the pair away and Clive dies of his injuries. What I want to do with this example is work through that understanding of murder to see if either or both of these parties will be liable for that crime. Let's start with Ben. Now, when we're looking at Ben, we'll usually be looking through the lens of principal liability. And principal liability is what we use to analyze the liability of people who actually perform the actus reus and actually have mens rea. So let's see if we can get a murder conviction on these facts. In terms of the actus reus of murder, the unlawful killing of a human being under the king's peace, how many of you think that Ben has satisfied that definition? Right, the vast majority of you. Why?
Because he shot someone.
Because he shot someone. It's pretty obvious. There's nothing that gets in the way between what he does and the death. So we are going to say that there is factual and legal causation there. No problems with actus reus. What about mens rea? So how many of you think he intended to kill or at least cause really serious injury to Clive? The hands are going up, but there's some hesitation. Why is there that hesitation?
Because initially he said that he was doing it for self-defense.
Right, so he's panicked. Why does that seem relevant to the question of whether he intended to kill or cause grievous bodily harm in your mind?
It was a matter of like a sudden occurrence, and in order to protect himself, he shot the person.
Yeah. So let's leave the self-defense aspect alone for a moment. The first part where you said it's sudden. Maybe it's because of the influence of American criminal procedure dramas, but we tend to think about premeditation as being really important to whether there is intention and particularly whether there's murder. English law, however, says you can form an intention to kill or cause grievous bodily harm on the spot. So it looks like you could say that even though he didn't premeditate to kill anyone or cause serious injury, he still had the relevant intention. Taking on your self-defense point, we have a rule that you cannot use self-defense if you have armed yourself in advance of the relevant attack. So if you go out with a knife just in case someone attacks you later, the law will just say, no, you can't have self-defense there. So that's how the self-defense element would be dealt with here. So it looks like we could, as long as we think that he meant to cause serious injury, convict him of murder. Defenses aren't going to matter here because it doesn't have any for reasons I've just explained. Ben is a murderer. What kind of sentence do you think that Ben can expect to receive upon conviction for murder? Over there.
Up to life.
Up to life, mandatory life. So he has to get a life sentence. Now, does that mean he will necessarily die in prison? No. Why is that? So we give you the life sentence, but you might actually get out of prison. How does that work? Yes, back.
Isn't the life sentence only 25 years?
That is one of the starting points for what we call the minimum term in your life sentence. So that's a good way of getting into this. The trial judge has to give you the life sentence, but they also have to set a minimum term that you must spend in prison before you can be considered for release. Now, in Ben's case, because this is a murder committed in the course of a robbery and he's taken the firearm with him, he can expect to receive around 30 years as his minimum term before he is eligible to be released. Now, importantly, that doesn't mean he automatically gets out after 30 years. He will have to behave in prison and show that he's not a danger to the public. But he can expect 30 years in prison, and then he is, in theory, susceptible to be recalled to prison for the rest of his life if he misbehaves when he gets out. So this is a serious sentence for a serious crime. That's Ben, then. What I want to do now is look at Andy, who was waiting in the car when this all happened. If we look at Andy through the prism of principal liability, we're going to be applying the same test. So what about the actus reus? Do we think that Andy has performed the actus reus of murder? No. Why not? He hasn't caused the death of anyone. I'm enjoying this sort of chorus response to answering. Causation requires you to be a but-for cause of the relevant result. So if we remove you from the equation, does the result still happen? If so, you haven't caused it. And we might say, well, Andy is a but-for cause of this killing because he drives the person who carries out the killing to the location. So had he not done that, maybe this murder wouldn't have happened. The problem, however, is that the law takes all of these factual causes of an event and then filters them through legal rules. And one of those legal rules is that if a human agent makes a free, deliberate, and informed choice to bring about a result, that severs the causal chain as it relates to other people. So here, Ben makes a free, deliberate, and informed choice to fire the gun. That relieves Andy of any causal liability for the death. The actus reus of murder is missing. What about the mens rea of murder? Does anyone think that that exists here? Yes and no. So who thinks yes? Okay. Why is that? Who wants to give me an answer? Yeah, right at the back.
Because he still knew that Ben had the intention to kill, even though Ben reassured him. He still knew that Ben had a gun on him.
So we might use that as evidence to infer that he did actually intend that someone would be killed, or he did intend that someone would suffer grievous bodily harm. And that's the approach the courts will take. They'll say the jury is entitled to look at this evidence of what he knew and what he knew about whether the principal was armed and make relevant inferences. So some of you said you were sure that he didn't have the intention to kill or cause grievous bodily harm. So if you were on the jury, what kind of reasoning would you be using to reach the conclusion he didn't? Yes.
Well, at the beginning, he had a conversation with Ben, and they both proved that Ben wouldn't actually shoot anybody. It would just be to scare off whoever was working at the bank. So therefore, there was no intent.
Right. So that is the debate that the jury would have to have. And the direction they would receive would simply be, did he intend to kill or cause grievous bodily harm? We don't tend to define those words any further. So the debate that you would be having is exactly the debate those 12 people would be having. So it's debatable whether he's got mens rea, but it doesn't matter because he doesn't have the actus reus. And defenses don't matter because if you don't have the actus reus, there's no point in asking about them. So in terms of principal liability, Andy is not liable for murder. Just intuitively, how many of you are happy with that outcome, that Andy does not have responsibility in criminal law terms for Clive's death? Precisely. So why do you have misgivings about letting Andy off the hook for this homicide? Yes.
Because he drove him away after he murdered someone.
Mm-hmm. So why do you think that makes it appropriate to hold him liable for the crime that's happened in the past?
When it knew it happened, it kind of allowed him to have the chance to get away from the scene. So he still contributed to it. Because, like you said, Clive died later on from the injuries. So it's not like he died right that second and then he allowed it to happen by driving him away.
Good. So another Americanism that you may have heard is accessoryship after the fact. So they often talk about how you're an accessory after the fact. We do not have that any longer since the mid-20th century. We have different crimes which are about assisting offenders. So would you be happy if he was convicted of assisting an offender rather than murder here? You would be. Or do you still want him convicted of murder?
Not convicted of murder, but assisting the offender. But also, to be fair, like, he did have to be reassured from his violent reputation. So I believe he did sort of have an idea that it could have happened. Why would you need to be reassured if you didn't think that it should have?
Right. So there is an element here of sort of unleashing a risk that this is going to get out of hand. So he's helping or encouraging a basic crime, robbery, and he's aware of a risk that this might get out of hand. And that might be one of the bases upon which we want to hold him liable for this death. Now, the law has the same sort of instincts that you have, that he shouldn't get completely off the hook just because he didn't cause this death with the mens rea of murder. As well as principal liability, we have this thing called accessorial liability. And the basic idea of accessorial liability is that you are convicted on the basis of someone else's crime. It's also sometimes called joint enterprise, which might be a term you've heard of in the media. So accessorial liability has got different actus reus and mens rea elements. The actus reus is aid, abet, counsel, or procure another person's crime. Now that language might sound quite antiquated, and that's because it comes from a statute from the mid-19th century. A lot of our law, in fact, comes from the mid-19th century that you'll be learning about. What do you think aid, abet, counsel, or procure means in more modern terms?
Or facilitate. To help or facilitate a crime.
Right, so assisting, helping, facilitating. That's usually the synonym that we use for aid. What about abetment? I'm sure you use the word abetment all the time in your everyday lives. What do we think it means?
Allow something to happen.
To allow something to happen or to encourage it to happen. If I abet you, it's usually that I've given you some sort of nudge to go on and do it. Or at least that's what the law says. So this, in modern terms, is broken down into assisting or encouraging another person's crime. assisting or encouraging another person's crime. The mens rea that goes alongside that actus reus is the intention to aid, abet, counsel, or procure another person's crime. So you have to intend to help someone commit a crime, or intend to encourage them to commit a crime. Now, remarkably, we've only been sure about that in the last decade. That test comes from a case called Jogee, which was decided by the Supreme Court in 2016. And we'll come to look later at what Jogee replaced. So if we're dealing still with Andy, we might want to distinguish between the robbery on the one hand and the murder on the other. So start with the robbery. Has he assisted or encouraged Ben to commit the robbery? Absolutely, no problem. Has he intended to assist or encourage that robbery? Yeah. Absolutely, no problem. So Andy is definitely on the hook for the robbery. The more difficult question is whether he is an accessory to the murder. Has he assisted or encouraged the performance of that murder? So some people saying yes, some people saying no. Those of you who say yes, why do you think he has plausibly helped or encouraged the murder?
Might have. Because the fact that he gave a weapon that was loaded and could have, that's an mens rea to facilitate be like causing the murder, because giving someone a gun that is loaded and then they go on to use that gun during that assassin pilot as well. It all kind of contributes to that could have led to a death, so therefore you have the mens rea of the murder.
Or the actus reus. Indeed. So there is an argument for saying, well, you did help him. You got him to the scene. You knew he had the weapon. You gave him the lift. Maybe we can read in that he gave him the weapon itself. There's an argument for actus reus, but it is sketchier than the argument for the actus reus of accessoryship to robbery. Sketchier is a proper legal term, I hasten to add. What about mens rea, then? Did he intend to encourage or assist a murder?
I feel like he didn't fully intend to aid or, because as people have said, he was the one who in that conversation was literally saying, look, you can't take this gun and you have a violent history. It's almost as if he had to be persuaded to have that intention to like let him go. And like, as you said, release the risk onto the bank.
Yeah, so one view of these facts is he has the exact opposite of the mens rea of accessorial liability. He's not intended to encourage or assist. He is intended to dissuade and stop that from happening. So the problem is that neither the actus reus nor the mens rea of accessorial liability for murder seem to be clearly satisfied. So that the high probability is Andy is going to be acquitted of murder on this basis as well. So knowing all that, how many of you still want Andy to be convicted of something in relation to Clive's death? Right. Again, the majority of you. So we need to look at how the Supreme Court dealt with such cases in Jogee. The Supreme Court said that there might be manslaughter liability in situations like this, and the test that they gave us for working out whether there would be manslaughter liability is as follows. Andy will be liable for manslaughter if he participates by encouragement or assistance in any other unlawful act which all sober and reasonable people would realize carried the risk of some harm, not necessarily serious, to another, and death in fact results. So we can break this test down into three elements. The first is participation in an unlawful act. So did Andy encourage or assist an unlawful act in the scenario we're dealing with? Yeah. What is it? Robbery and assault, because he does say, look, if it comes to it, point the gun at these people. Don't shoot them, but point the gun. That's an assault. If we focus on the assault, the second element that we need to find proved here is dangerousness. And dangerousness is the all sober and reasonable people would realize that the unlawful act carried a risk of some harm. So was the assault, pointing a gun at someone, dangerous in this sense?
Yes.
Yeah. Why? Maybe one person put a hand up. Yes, there. Sorry? I can't hear you, sorry.
There was a chance it would be triggered.
Right, the gun might go off. So it's not saying that this was a chance that someone would die, it was just a chance that some harm would come about. The gun might go off accidentally and graze someone on the arm or something. The assault is definitely dangerous. Has it caused death? Yeah. So on the Supreme Court's analysis of these facts, Andy would be liable for manslaughter. Now, I say on the Supreme Court's analysis of these facts because an important aspect of studying criminal law at university is we teach you the rules and then we begin to appraise them critically. We begin to ask, look, do these really make sense? And the problem here is that this analysis of manslaughter does not really make sense. What killed Clive? Was it the assault with the gun accidentally going off, etc.? No. So the Supreme Court hand waves that problem away. It does not actually resolve it. And so a number of academics have said, this doesn't work. So actually, if you follow the logic of your decision, you should be convicting him maybe of assault as a secondary party, but not of manslaughter. So one of the things you would have to do in a university course on criminal law is decide how convincing you find that critique and how convincing you find that outcome. What kind of arguments do you think you could make in favor of this result, that he's convicted of manslaughter rather than no homicide at all? Yes.
Because carrying a gun always has the serious threat of maybe harming someone, and that's what it says. So.
Yeah. So we might say, yes, okay, there is a causal problem here. The thing that he encouraged or assisted didn't actually kill anyone, but he still unleashed this huge risk by allowing his co-adventurer, as we tend to call them, which sounds rather quaint, to go ahead with the gun. Yes.
Can you say as a counter-argument, like you said, the other guy, sorry, I don't remember his name, he made a free, deliberate, and informed decision to use something like Andy doesn't have responsibility for what another adult decides to do.
Aha! Now, accessorial liability is an exception to that principle. Because that principle exists, which says, look, the person who actually shoots and pulls the trigger breaks all causal chains, we have to find another basis for saying you're responsible, and it's this accessorial liability that we use. If you'd been told about Andy's doubts about Ben's violent propensities, etc., before he left in his car to go on this robbery trip, if that's the proper term, what would you advise Andy to do? Don't go. So another argument in favor of this manslaughter conclusion is you had a very easy way of avoiding this situation, which not just foreseeably got out of hand, but you'd actually foreseen might get out of hand. So another argument that was often put in place to defend this manslaughter liability is this is just reaching the appropriate result based on deterring people from going on these joint criminal endeavors. Now, I said earlier that I would mention what Jogee replaced. So it used to be, before 2016, that we had another type of accessorial liability. That was often referred to as joint enterprise, but the courts decided on the far snazzier and memorable title of parasitic accessorial liability, which really rolls off the tongue. So apart from having problems with branding, this type of liability was thought to be unfair. So it came from a decision in 1984 called Chan Wing Soo. And in Chan Wing Su, the following requirements were set down for parasitic accessorial liability. So 1, the defendant that you are analysing agreed with another person to commit crime A, as it was often called. Whilst doing so, the person that you are analysing the liability of foresaw the risk of crime B being perpetrated. Crime B was in fact perpetrated in a way that wasn't fundamentally different from what the person we are analysing had foreseen, and as an incident of the agreement to commit crime A. Let's apply that to Andy. Did he agree to commit crime A? Yes, the robbery. Did he foresee the risk of crime B? Yes, because that's why they have the discussion about, like, please don't shoot anyone. Was crime B, in fact, committed? Yes. In a way that wasn't fundamentally different from what was foreseen? Yes. And as an incident of the agreement to commit crime A, rather than, as the courts put it, a frolic of one's own. Yeah. So parasitic accessorial liabilities requirements would be satisfied here. And the consequence of that would be that Andy would be convicted not just of robbery, crime A, but of murder, crime B. Now that has important implications because procedurally, we don't care whether you were a principal or an accessory. You are convicted of the same crime, so he's convicted of murder, not being an accessory to murder, and we apply the same penalty. So if you remember earlier, what was the penalty that Ben would receive? Life with 30 years as a starting point. That is the predicament Andy would find himself. A mandatory life sentence. And although his sentence would probably be reduced to reflect the fact he didn't carry out the actual shooting, he would still be in prison for a very significant period of time before he could apply for parole. So this is the form of liability that was got rid of in Jogee. Why do you think that this form of liability was got rid of? What was that, sorry? Yeah.
The prisons.
So one argument is it was overflowing the prisons. What are some other arguments?
Harsh.
Too harsh. Why?
He didn't actually kill the guy. He just like helped without doing the crime.
Yeah, but on the other hand, he still foresaw that this was a risk that might happen, and he was undeterred. So he obviously didn't care that much about whether someone died on this enterprise, or else he would have stayed home. What do you think of that logic?
Again, it's like it's free an individual person making a decision that, like, and he couldn't have, like, it's true he could have foreseen it, but it's up to the other guy to do what he wants to do.
So we might think that although he's involved in that crime, he's not involved enough just because he agreed to something else with foresight of how it might escalate. Yes.
But considering that this is like quite a direct effect on the actual murderer's action, and the jury would take in mitigating factors anyway, then surely that means that this person should be criminally liable. Otherwise, why would they take in mitigating factors? It doesn't affect either.
So one counter argument to that is we are overloading the sentencing phase with considerations that should work at the liability stage. So we should be taking into account that mitigation in terms of what you're actually liable for, rather than just saying it'll all come out in the wash because when we sentence you for murder, we'll actually give you a discount or something. So what do you think about that? Do you think that the law is right to now put more of this stuff in what you're liable for? Or do you think it was justifiable to have this as the liability test and deal with it at sentencing?
I think in terms of like determining liability, taking in like other factors that aren't necessarily pieces that were actually accessory to the crime is also important. And by adding loads of different more things to determine how liable you are, I think that's better than having like a set precedent, because it's not going to work for everyone at the end of the day.
Yeah. So what we now have is a situation where this cannot work. You have to put liability through one of the two earlier models that we looked at. So before I finish, I want to know which of these outcomes you actually think is most defensible. So the parasitic accessorial one that we finished with is they're both liable for robbery and murder. How many of you think that is the right result to reach in this case? None of you. So the Supreme Court probably got things right by getting rid of parasitic accessorial liability in terms of what everyday people think is fair. And the criminal law should care what everyday people think is fair, because who decides serious criminal cases? Juries, which are ordinary people. So if the law becomes ridiculously harsh, juries just wouldn't apply it. So maybe they were right that the everyday person would think this is just too harsh and spreads the net of liability too widely. What about the middle ground then that we seem to have reached, which is that Andy and Ben are both liable for robbery, Ben is liable for murder, and Andy is liable for manslaughter? How many of you like that answer? Right, so again, even though I noted earlier there is a principled problem with that conclusion in Jogee, it does seem to accord with most people's intuitive sense of justice. If one contrasts option 3, Andy and Ben are both liable for robbery, Ben is liable for murder, and Andy is not liable for any homicide offense. How many of you want that outcome? Right, exactly. So there is an argument that if you follow the logic of Jogee, 3 is where you should end up. But as I said, the Supreme Court was quite clear that 2 is the answer nowadays. Now, I'm aware I started a bit late, so I'm going to have to finish a bit early to get you back on time. But that's hopefully given you a good flavor of what studying criminal law is like at university. Thank you.